Good afternoon. My name is Allison Baker. I'm a partner here at Venable, and thank you very much for joining us this afternoon for our webinar, the CFPB's new arbitration clause ban, How to Prepare Your Organization. And this afternoon I'm joined by a great panel of colleagues. We will be hearing from Peter Frechette about the background of the rule. We will be hearing from Tom Gilbertson on class actions and what this means in light of the proposed rulemaking. We will be hearing from John Cooney about potential challenges to this rule and the general legal landscape on a going forward basis. And we will be hearing from Jonathan Pompan about how to prepare your organization to comply with this rule and how change management should be effective given the proposed rulemaking. And with that, I want to start with Peter. And I want to note that our presentation today involves a number of slides, including a fair number of slides that provide some detail and some description about the rule itself, the proposed rule, as well as the study that the CFPB did pursuant to Section 1028 of the Dodd-Frank Act as mandated, that is the precursor to the rulemaking. And although we have them included in our slide presentation, we're not going to be discussing in detail today a lot of the earlier history of this rulemaking. One, because I think it's something that most folks on the call are already familiar with, and two, because we have a very packed presentation today and we want to get through our presentation. But having said that, if anyone on this call has any questions about any aspect of the slides or the background relating to the rule, please feel free to reach out to any of us, any of the presenters today, and we're more than happy to answer those questions either through email or phone, etc. With that, I will turn it over to my colleague, Peter. Thank you so much.
Thanks, Allison. As Allison noted, I'm going to be going briefly through the proposal, some of the background, a lot of which has been covered throughout this process. So we'll move fairly quickly through that and into the meat of our discussion. So just to quickly look at the timeline of the rule, just to refresh ourselves and sort of moving through May of 2016 when the NPRM was published, and then out to August when comments are due, just getting a sense of the length of time the Bureau has been sort of ruminating on this, developing its study, developing proposals, and then ultimately proposing a rule, and gives us a sense of the weight behind this. It's, as people have noted, it is one of the bigger, more broad-reaching, and certainly has garnered a lot of attention, rules that the Bureau has done. So it's certainly going to be an interesting couple of months throughout the comment process.
And before we continue, I just want to note as well that the slide presentation that we're currently going through will be available after today's webinar for download as well. Thank you.
So the proposal that we've seen creates a new section of 12 CFR to house the arbitration rule. And it's a fairly straightforward, I would say, proposal, and very similar to what we were expecting. Everyone was kind of anticipating the NPRM to read. Basically, the first prong of the two-part proposal was eliminating agreements that create barriers to participation in class action. That really is the crux of the proposal, is keeping those barriers out, and so often that they will appear in arbitration agreements that create those barriers. And then the second is submitting arbitral claims, awards, and other details to the Bureau for potentially some form of public posting, but also Bureau analysis as they move past the threshold issue of eliminating agreements that prevent consumers from participating in class actions, and possibly look towards taking a finer approach to regulating arbitration itself in the future. So as a little bit more detail, the first part of the Bureau's proposal would, A, prohibit providers, anyone covered under the rule, from relying on pre-dispute arbitration agreements. And then the second part, as you see that second bullet, there'll be required language that you'll need to include in those agreements. I won't read it, but you have it on the slide, and it's basically to the effect that you're indicating, notifying consumers that you're not going to rely on that agreement to block a class action, let's say, and you notify them sort of their rights, basically, of their ability to participate in a class action under the rule. That's, again, a fairly straightforward approach to the end goal that the Bureau seems to be trying to reach. There are some, I think, not side issues, but there are areas where people can comment that might not go to the core of what the Bureau is doing, but certainly are going to affect who's included in this rule, who's affected by it at the end of the day. So one of these areas is the Bureau is interpreting language from Dodd-Frank, Section 1028D, which requires that the rule apply to pre-dispute arbitration agreements entered into after the compliance date, and that's how the Bureau has framed its rule. But it's interpreting that term entered into, and so that you see discussion in the NPRM, and this will be, obviously this is just teeing up this issue, and it'll be something for discussion and comments throughout the next couple of months. But what does entered into mean? And the Bureau has provided some proposals, some guidance. Basically, those dashes at the bottom, providing new products or services, excluding new charges on credit cards, as they noted in the NPRM, acquiring or purchasing a covered product, and adding a pre-dispute arbitration agreement to the existing product would all be entering into a pre-dispute arbitration agreement. And the compliance date, again, is going to be that date after the final rule is issued, 30 days after issuance, and then per Dodd-Frank, 180 days after that. So it's a 211-day count from when the final rule comes out. So moving forward a little bit there, back to entering into, again, they provide some proposals about what they exclude from that term. And two of those there that we highlight are modifying, amending, or implementing terms, or acquiring a product subject to a pre-dispute arbitration agreement without becoming a party. And again, here too, that second bullet, certain entities that are acquiring consumer financial contracts may need to amend those contracts under the rule. So there's that possibility with both the entering into interpretation and that aspect of acquiring, becoming party to a consumer financial contract that has a pre-dispute arbitration agreement that could apply retroactively in a sense. And so industry participants are going to need to be aware of these, and we'll be commenting on them. And again, another aspect of the scope is who this affects. And the Bureau has stated that it affects certain consumer financial products or services in the core consumer financial markets of lending money, storing money, and moving and exchanging money, including, amongst others, and then there's not a laundry list, but a set of bullets that include some of the examples of types of companies that are going to be covered by this. I won't go through them all, but while it's not the entire scope of the CFPB's jurisdiction, it certainly is broad and will be subject to comments as we move forward, both pro and con, expanding and also contracting. And there are certain exclusions, limitations, and carve-outs. I think the big two there are if you have certain agreements that are already subject to arbitration rules, and then that last bullet too, agreements involving products or services provided by persons excluded from the CFPB's jurisdiction. And another point I just wanted to raise, it's not in the slide, but this does bring up the fact that the rule is going to cover products and services agreements, basically that could result in companies offering certain products or services that might not be covered. So you're going to see the situation potentially where you have a mix of products or services, a mix of contracts you offer, and you're going to have to decide whether to writ large take out your arbitration agreement as sort of an efficiency, or whether or not you approach it more granularly. And we'll talk more about this towards the end of the program when we talk about compliance and getting ready to comply with the rule. Just quickly moving through the authority, again, we're going to talk about this a little bit more in a second, but 1028 forms the basis for this rule. It also, as we've seen, kind of constrains the Bureau in certain respects, especially with the effective date, but also, as we've seen, with that entered into language. So this is going to be something that people are interpreting, disputing, or trying to support the Bureau's interpretation of. So very, very important to be aware of. Another section of Dodd-Frank which comes up is the Bureau's Rulemaking Authority, which is 1022. I've included a slide that has part of that section again, and just focusing on 1022B to A. We'll talk about this a little bit later, but the potential costs and benefits analysis of the rulemaking and how that comes into play.
So, Peter, there's something that you touched on before that I think is really interesting and important to think about, which is instances where a product or service may not be within the scope of the CFPB as contemplated right now, but you could see a scenario where that is somewhat of a moving target because the concept of jurisdiction is changing a little bit each day with the CFPB. And so I think it's just it's worth noting that just because you think a product or service that you offer right now may not be something that's ostensibly within the scope of the Bureau may take a different perspective on that, particularly if it involves a financial service or product in some attenuated way. And I think that in terms of planning and thinking about how this rule could apply, that's helpful as well.
And also, too, this is Jonathan Pompin here. Good afternoon, everyone. You have a scenario here, too, where you could actually not consider yourself a financial services provider, or maybe one of your vendors doesn't consider themselves a financial services provider, and the product or service could still be encompassed under the expectation of the CFPB to fall under this prohibition on class action waivers. There's actually, in the Notice of Proposed Rulemaking, a considerable discussion of a lot of products and services that the CFPB to date has not actively sought to regulate, certainly usually associated with companies that are not currently under the non-bank supervision rule. And so there is if you were to do a Venn diagram here, in many respects this is actually a rule that could be far broader and, as Peter mentioned too, granular than anything that the CFPB has done to date. For those of you who are doing vendor management, you're going to want to look at products and services on a very micro level. And then the flip side of that is for companies that are in the financial services space, there is a potential here that you have products and services on the books and out in the marketplace that are going to be covered by this rule that have not yet been looked at by the CFPB if you're under supervision, or have not really been on the radar as being of interest to the CFPB. And there's dozens of pages in the NPRM where they go into great detail about juxtaposing the scope of this rule versus the scope of some of their other authorities.
Exactly. No. And just quickly wrapping up the discussion of the background, you can't talk about this rule without noting at least the Federal Arbitration Act and how that and the Supreme Court cases sort of flowing from that act are going to intersect with this rule. Again, we'll touch on that briefly later in the presentation. And just to wrap it all up, again, the public comment period, we're actively in that period, which will run for 90 days, ending August 22nd. It's an important and actually crucial time, whether you're simply commenting to try to get your views to the agency to affect the eventual final rule, or even if you're contemplating litigation, companies, organizations that might be contemplating litigation here, contesting that the final rule is arbitrary and capricious, you need to use this comment period to build up the administrative record. You can't complain that something is arbitrary and capricious based on facts that aren't in the record. And it's really going to be the industry's burden here to get those facts that it needs into the record. So I think it's an important time, really an important consideration as we move forward. And again, just quickly, the comment review period where the Bureau will be digesting the comments that come in, finalizing the proposed rule, no firm timeline or time frames there, but then implementing the final rule, again, under the NPRM and Dodd-Frank is a 211-day period from issuance. So with that, we're going to turn it over to Tom. Well, quickly wanted to note that we have some slides on the arbitration study, which again we'll reference, but we're not going to specifically go through these slides, but they're here for your review should you want to do so, and then I'll turn it over to Tom.
So Tom, I'm hoping that you can, thank you, Peter. I'm hoping, Tom, that you can give us some sense of, given your practice as a class action defense attorney, you can give us some sense of how this is likely to impact that practice on a going forward basis. And one of the things that I think is very important to understand is both the way that this changes the calculus for risk management, and two, the way that this potentially changes some existing jurisprudence, particularly in the consumer finance space. I mean, it's a pretty litigated area, but nevertheless, if you have a larger number of class actions out there, there's likely to be more, and perhaps in some ways more directives coming from courts about the way certain statutes and laws get interpreted.
Thank you, Allison. And yes, my principal concern is that this rule will act like a class action magnet for companies that are and entities that are under supervision. And for the reasons that you and Peter and Jonathan were just discussing, I mean, all the different covered products and the ways that you can come under this rule, plaintiff class action lawyers are going to be looking at that. And where it's a situation where an uncovered merchant has an arbitration clause that's going to be enforced under Concepcion, the strong incentive is going to be to get out from under Concepcion and to get within this rule. So plaintiff class action lawyers are going to be looking for a way to bring covered entities into their claims where otherwise they may not have before. And so we're going to see a lot of, vicarious liability theories being fleshed, maybe RICO cases, any kind of claim that goes to collusive or collective action. And in that way, I think there's a real concern for financial services providers that this rule is actually going to attract class action litigation. When we convened back in February with this panel, we talked a little bit about the history of class action dynamics and what led us to this point. And I was intrigued to see in the proposed rule that the CFPB, they went through a lot of this history themselves in the proposed rule, and it was interesting to see their perspective of what they view as kind of the cross-current of competing trends here. We've got increased use of arbitration clauses and class waivers that started to arise throughout the 80s, the 90s, the previous decade, as all manner of companies and merchants were trying to get a handle on the class action explosion that was happening under Rule 23. And at the same time, there were some legislative responses, and the CFPB, brings these out in their proposed rule. FINRA is one of them. In 1992, they passed and enacted a similar regulation that limits the ability of the brokerages and the FINRA-regulated entities to rely on arbitration agreements to avoid class actions. Of course, there were other legislative responses as well, including CAFA, which doesn't get as much play in the proposed rule. And one of CAFA's main findings was that really individuals aren't that well served by these class settlements, and you don't see CFPB really drilling down to that. There's more of a concern of preserving the class action device because there's just a bias in favor of it. But the Class Action Fairness Act of 2005 and CAFA, there were a number of findings about really the limitations of the class action device as a benefit to consumers. And then the third cross-current, obviously, is the decisional authority. Some of the rulings that have come out of the Supreme Court recently, what led up to them was a variety of trial court and appellate court decisions where arbitration provisions were getting inconsistent treatment. Sometimes we'd get them enforced, and sometimes they were being adjudicated as being unconscionable procedurally, substantively, and courts were not enforcing them. And there was a rule in California that got set up by the Supreme Court that an arbitration clause with a class action waiver was presumptively unlawful and courts weren't enforcing it in California. That's what led to the Concepcion case about 5 years ago in the Supreme Court that held that Discover Bank rule was an obstacle to the Federal Arbitration Act, and therefore it was preempted. And that also class-wide arbitration, arbitrating class issues, which was never an attractive proposition in my humble opinion, was also inconsistent with the consensual nature of the FAA. And a couple of these other cases that are noted in the screens here, the screenshots, you can read the history that the CFPB has given to those. I think we're missing a screen there, but one case that was not discussed in the proposed rule was Spokio. Although they saw it coming and there's a placeholder for it, that decision, Allison, is having a big impact for, the entire corporate America and not just financial services companies. And it's a great decision that imposes a concrete injury standing requirement on all class actions, but in particular, the usual suspect class actions that clients in this space face: FCRA, TCPA, the Fair Debt Collection Practices Act, Tyler, RESPA. These are the class actions that the supervised entities are a big nuisance in the space. And I think that the good news is that Spokio is going to help manage through those actions. So if we're being shoved back out into the class action arena, there are still a lot of great tools left for financial institutions to manage their way through that and come up with good outcomes.
So Tom, I think if you can maybe amplify a little bit about Spokio and why it's so significant and how it's an interesting timing issue here. One of the concerns, of course, with class actions in general, and in particular in the consumer finance space, is that often they arise from what could best be described as potential technical violations of a law that don't necessarily result in any cognizable consumer injury or harm, at least not in the way that one's traditionally accustomed to thinking about that in the class action context. And Spokio, I think, puts some meat on those bones in a way that's pretty favorable here.
Right, the decision, I've defended any number of TCPA and FDCPA, FCRA cases, and there are a variety of state statutory regimes. Like in California, you've got the California Invasion of Privacy Act, where the statute gives consumers a per violation penalty to pursue. Maybe it's $1,000, and those add up in a hurry in an aggregate action. And what Spokio decided in the Supreme Court just last month was that it's not enough for a plaintiff to point to a violation of the statute and to say that they were on the other end of that violation. They have to identify a concrete injury. That's the type of injury that it makes legislative history, I think, kind of an important factor to address in these cases. But it has to be the type of injury that the statute was designed to address, just like antitrust injury in a way. And in all the cases I've defended, I've rarely seen a named plaintiff that had suffered real economic loss. They're always saying, and many times they disclaim any economic injury or any concrete injury because they want to maintain typicality with the class. So they make a point of saying, I don't have any other injuries, I'm just here for the statutory penalty. And I think that play is out of the playbook for plaintiff class action lawyers. It not only makes these cases harder to get up and running, but when it comes to certifying them, it means we're dealing with a much narrower class, and the ascertainability issue of finding a sufficient number and being able to identify from objective criteria the customers who have concrete injuries, it's a much more difficult proposition.
Thank you. So just a couple of reminders. If you have questions, please feel free to put them into the chat function on our webinar, and we will answer those questions toward the end of our presentation. We'll leave about 10 minutes at the end for that. And I'd like to have John Cooney speak a little bit about some of the foreseeable legal challenges to this rule as we speak and sit here today. So John, if you could give us your thoughts on that.
Good afternoon. I thought I would try to walk you through first some general process factors that would affect this kind of major litigation against a major rule, and then go to 4 legal challenges, possible legal challenges, all hypothetical at this point, that I've heard people discuss, and walk you through some of the major features there. The process factors simply reflect the fact that there are many different legal challenges that can be filed against a rule this important by many different parties who are adversely affected in many different ways by its provisions. Typically, litigators divide these challenges into 2 categories involved in such big rules. First, there are sweeping challenges to the broad thrust of the rule. For example, here, limitations on the use of arbitration provisions that are established by statute. And second, there are smaller scale challenges to specific provisions or applications of the rule. For example, how the rule might apply with respect to a specific consumer financial product that might not fit the mold of others that the agency is going to regulate. The point I want to emphasize is that the sweeping challenges tend to consume many more pages in the briefs that are filed by the challengers to these rules, and they tend to crowd out the narrower, more specific challenges. This kind of page limit or word limit compression phenomenon is especially acute in the appellate courts. It can be very difficult for parties with specific challenges to specific parts of the rule to get the space that they need to have their arguments presented fully to the courts. The space is allocated by negotiations with a managing group, typically, of trade associations and large companies that are filing. And they tend to focus on the broad issues that will help everybody if they're accepted by the court. And it can become a real fight for a company that has a specific complaint about the rule to get that into the briefs in a meaningful way. It's not possible to tell now what kind of narrower, more focused challenges might be filed or might be available to challengers. We won't know that until the final rule is issued. But the thought I want to leave you with, it is very possible to tell you now that if your company has a specific challenge to a small part of the rule, you're going to need to be very aggressive and work hard with the managing groups to make certain that your arguments are adequately presented to the court. And one last process point, which is typical of all forms of administrative litigation, but I wanted to make certain you heard it before we leave this area. And I want to emphasize the critical feature of the comment period, which is that challengers must submit for the administrative record all the factual information that will be necessary to show that the rule is ill-advised and harmful, especially if you have specific issues. You need to include in your comments all the evidence that you think your litigators might need if you eventually come to challenge the rule. And that's, if it's not in there in the comments, then the courts cannot consider it. So let's turn to the more conceptual part of this, the possible challenges to the rule. First, there's been some discussion of whether it will be possible to bring a challenge based on the Bureau's arbitration study. As Peter pointed out, under Section 1028A, the agency is required to conduct a study of arbitration before it issues a final rule prohibiting or imposing conditions on the use of arbitration agreements in connection with the offering or providing of consumer financial products. The findings in the final rule must be, quote, consistent with the study, close quote, whatever that means. The point I want to leave you with is that this standard will give the Bureau substantial flexibility in drafting a rule that could be deemed to satisfy the consistency study. In part, this is a function of the definition of consistency, which is conforming to the same principles or causes of action. It's very general, and the agency knows that that will be a weapon on its side. And the second point is that the agency has known for years that this possible challenge is out there, and it undoubtedly worked on the study and articulated the conclusion of a study in a way that it knows is going to support the conclusions that it ultimately wants to reach in its final rule. So we know that there is a possibility that this issue could be raised, but we won't know if it's a significant legal issue until we all read the final rule and see how the agency has anticipated this challenge and has prepared its defenses.
John, that issue of how closely the proposed rule and ultimately the final rule conforms to the Bureau's arbitration study is something that I think keeps percolating. And I agree with your assessment that consistent with the study is a pretty broad statement and one that the Bureau can obviously use however it chooses, I think. I'm curious if you have thoughts about that. I mean, would that be the kind of issue that would be susceptible to, I would imagine, susceptible to an APA challenge, assuming you could argue it was not consistent with the study?
Right. And another rule of administrative litigation is if you want to bring a challenge, it has to be foreshadowed in your comments. And so if people say, what you're proposing to do in my area is not consistent with the study, the agency will review your comments very carefully, and you can count on them including paragraphs in the preamble to the final rule that will try to show why they are consistent. So it's one of those catch-22 situations that the agency will educate itself from your comments and will try to solve that problem in advance. I think of this as the general part of the agency preparation. They know it's coming, they've been thinking about it for a long time, and they will pay careful attention. So let me move on to the more substantive legal challenges now that preliminary threshold process challenge we just discussed. And the basic thrust will be, does the agency have delegated authority from Congress to implement the rule that it proposes to put out? And this will probably be broken down into multiple categories based on the broad legal issues and some of the specific issues, as I discussed before. Under Section 1028B, the CFPB can prohibit or impose limits on the use of arbitration agreements if it finds that such a prohibition or limitation is, quote, in the public interest, and also, quote, for the protection of consumers. In the proposed rule, the Bureau made a big point about the fact that it's going to separate this provision into two inherently interrelated tests that it's going to apply. The public interest standard will be used by the agency to focus on the entire range of impacts on consumers and other members of the public, including the primary effects on consumers that they can't be forced into arbitration, and such secondary effects as impacts on pricing, availability of products, innovation, accessibility, and something called general systematic considerations. The agency is going to use the For the Protection of Consumers branch of the statute to focus on the effects of the rule on promoting compliance with laws applicable to consumer financial products and services and avoiding harm to consumers. And I'm not certain exactly what the agency is driving at in emphasizing the two aspects of the definition, but I may suggest one later, which has to do with the possible cost-benefit challenge that might be brought to the rule. Just based on the language, the thing I focus on immediately is the public interest standard. This is an extremely broad test and has been upheld by the Supreme Court in a series of cases starting in the early 1940s. And the court has held that something that says protect the public interest is a sufficiently precise delegation of authority that it passes the constitutional test imposed by the delegation standard. And so that this is permissible. And obviously a standard that says the agency can go out and promote the public interest gives the agency extraordinary latitude in justifying a rule, as long as there is some factual support in the administrative record that shows that the provisions are reasonable and gives the reviewing court enough to hang its hat on. So there will be a lot of focus on the public interest standard, but you need to understand that that is the broadest standard that the Supreme Court has ever upheld in granting authority to the agencies, and one that they have been highly successful in using to defend rules that are justified by that standard. The third test I want to focus on that I've heard something about is that there have been suggestions that Section 1028B could be challenged on the ground that it's unconstitutional because Congress did not properly delegate authority to the CFPB when it gave the agency authority that in practice, in effect, allows it to partially repeal the Federal Arbitration Act in this area. And I regard this rule, this argument, as a real statement of frustration on behalf of the companies and industries that spent a lot of time litigating to establish the law that the state bans on arbitration provisions violated the Federal Arbitration Act, and here you have many of the same considerations coming back in from a different direction. So my principal reaction to the delegation argument is that you need to consider this in the context of efforts that are underway by conservative legal professors who are concerned that the administrative agencies are now out of control and not subject to effective control by Congress. These professors have been developing a series of theories that they want to try to get the Supreme Court to adopt that would develop some kind of workable criteria that could be applied by the courts to force Congress to be more precise in the terms in which it delegates authorities to the agencies. There are no Supreme Court cases in force today that establish these kinds of criteria other than the ones I mentioned that accept the public interest criterion as a viable standard. So the professors are looking to establish new law that would require Congress to take political responsibility for its decisions and delegate in more precise terms. And I think that if a challenge is brought to Section 1028 under this kind of broad delegation theory, it's highly likely to be caught up in the broader law reform effort that is going on in conservative legal circuits, conservative legal groups, to persuade the Supreme Court to adopt more general limits on how Congress may or may not delegate authority. And then finally, as I foreshadowed before, I want to bring you to a potential challenge to the CFPB's cost-benefit analysis. As Peter showed you on an earlier slide, Section 1022b2 says that in promulgating a rule, the agency must consider the potential benefits and costs to consumers, including the potential reduction of access by consumers to consumer financial products or services, a point that I think is going to be emphasized repeatedly in the comments, that this will reduce access by consumers, reduce innovation and introduction of new products. And so there'll be a real effort to put as much weight as possible, including the potential reduction of access by consumers. But other than that, this 1022b2 requires the agency to prepare a broad cost-benefit analysis of the rule without putting specific criteria in place as to how that cost-benefit analysis should be conducted. The important point to know here is that this aspect of the case also is likely to be brought up in the context of a significant legal reform effort that's underway. In 2015, the Supreme Court issued a decision called Michigan versus EPA, Justice Scalia's last major administrative decision, which suggested that there are 4 judges on the Supreme Court who thought that the cost-benefit analysis should play a larger role in review of agency rulemaking activities. And since then, a series of cases are being filed throughout the country on the general ground that the agency did not conduct a proper analysis of the costs and benefits. Now, there is no requirement that the benefits of a rule exceed its cost in order for it to be issued, as long as the agency can come up with some reasonable justification for its actions. But as an empirical matter, these kinds of challenges tend to be brought most often in situations where the quantifiable costs of the rules exceed the quantifiable benefits. I think that the agency has thought about this a long time and came up with an approach that's going to form the basis of its defense to any cost-benefit challenge. The proposed rule suggests that many of the costs are quantifiable, whereas the benefits are not quantifiable to any significant extent. In making the argument that the costs aren't quantifiable, the proposed rule repeatedly cites works by Judge Richard Posner of the Seventh Circuit, who was the inspiration of the entire law and economics movement. And Posner's work emphasizes the proposition that the benefits of rules typically are, rules like this would be that arise from having regulated industries committed to greater conformance to consumer protection laws, and deterrence, that is, people won't violate the laws as often. And those benefits are inherently not quantifiable. There's no way that an economist can cite them. And the fact that the agency relies so much on Posner tells me that they are prepared to use conservative legal doctrine in a jujitsu move to try to defeat what inherently is a conservative argument that the agency acts irrationally when costs exceed benefits.
John, this concern about risk, the assessment of risk, and how the assessment of risk, especially in the class action arena, affects the cost-benefit analysis. I'm kind of trying to tie together what you're talking about with cost-benefit analysis with some of the risks associated with increased class actions, Tom, that you discussed. And I'm wondering, Tom, what your view of that narrow issue is within this cost-benefit framework, which is obviously something that's mandated, all agencies have to consider. And I want to also note that we've discussed at length Section 1028, which is the provision in the Dodd-Frank Act that mandates this arbitration study and allows for a rulemaking. But Section 1022 of the Dodd-Frank Act is the provision of the statute that enables the Bureau to promulgate rules in the first instance. But getting back to your question, to the question I had for you, Tom, about cost-benefit analysis and how that plays into the risks associated with class actions and an increase in those.
Well, I think that the increased exposure to class liability, the way the Bureau seems to be looking at it, I mean, to them, that's a benefit. Allowing consumers in the financial services arena to, collectivize and to have that leverage as they bring their complaints to the financial institutions for resolution, they would count that up as a benefit. But I think to John's point, quantifying the benefit to consumers, you're not really done unless you go and you look at the empirical record of what people are getting, what individual consumers are getting from class action settlements, and that's precious little. In fact, if I had an individual claim against my bank or credit card company and I had a view of getting it resolved, but there's a class action and now a class has been certified, that sweeps my claim right out of my hands, and now it's in the hands of a court, it's in the hands of some faraway forum, a class action lawyer to get resolved unless I take affirmative steps to opt out. And of course I'm unlikely to do that for a claim that's of a smaller value, by which I mean maybe thousands instead of millions. And opt-outs are usually large dollars are involved that make that a wise move. But the class action device actually takes individual control of my claim out of my hands, and I think that's something that really gets lost.
And this is a good segue into Jonathan's discussion about how companies that are potentially or actually within the scope of the CFPB and likely to be within the scope of the arbitration rule should be thinking about their regulatory compliance in a forward-looking way, and how do we manage this process. And Jonathan, if you can talk to us a bit about that as well. Thank you.
Thanks, Allison, and thanks, everyone. Today's discussion so far has focused on the over 300 pages of the Notice of Proposed Rulemaking that provided justification for the rule, as well as the 10 pages, a lot less, that actually has the proposed rule in it. And of course, the proposed rule doesn't completely ban arbitration. It just bans class action waivers. But as many of us know from practice, an arbitration provision without a class action waiver is a recipe for disaster, because you can end up very quickly in a class action arbitration, which has been known to happen from time to time, and they're not pretty when you've got one person deciding the fate of an entire class.
No appeal.
With no appeal, that's right. And not the same rules of discovery either. So that can be a morass that is just intolerable for companies. And so as a practical effect, what we've been talking about, and most practitioners are assuming, and I think most businesses are assuming, is that the arbitration provision as you know it is not going to be the same if the rule takes effect. So the big question is what should covered entities do? What's next? Well, the good news is first and foremost, there is some time. In fact, there may be more than just some time. There may be a lot of time. It really depends on what the status and next steps are in terms of these challenges that we've been talking about. Conventional wisdom is that there will be legal challenges against the proposed rule, and presumably there'll probably be even litigation after the rule would take effect, if it does ever take effect. The interesting thing is, too, is that the rule takes effect 211 days after it's released. That likely puts us into sometime in late 2017, maybe even 2018, depending on the schedule here. And again, the legal challenges, and that's also well into the next presidential administration, perhaps the next new CFPB 2.0 as well. and a lot of other things. But we can speculate for the next 5 hours on what's going to happen next with respect to the rule and the CFPB in Congress. But as a practical matter, companies now do need to start thinking about what's next in terms of internal. The rule is no longer a proposal in the sense of the draft outline that was released last year. It is now something that is black and white. It's on paper as a proposal that, with probably little change, will become the final rule if it's released. And so the question becomes internally for companies, what do we do? And so I think the most important thing to do is to follow the compliance management system that most covered, if not all covered companies, have actually deployed in the last 5 years of the CFPB, if not even earlier, and assemble the right team of folks. And we'll talk about that in a moment. But I think most importantly, whatever team you do assemble needs to understand the requirements. That's the reporting requirements of the new proposed arbitration rule, as well as also how it impacts portfolios where you have the potential where you may sell or assign a portfolio of loans if you're a loan provider, as well as also how this impacts existing contracts, which is it shouldn't. So there's a lot of different requirements here, intricacies with respect to how the rule would be implemented in practice that I think need to be thought through. Now, the impact is also extremely important. What is the impact? Now, we've talked a lot about theoretical impact, but as a practical matter, the reality is that the pricing, the profit margins, the risk tolerances for error, technical error with respect to compliance with the technical aspects of laws, all likely will change if you don't have this last line of defense. And so as a result, you've got to take a close look at how you would factor that. Now, not just on a big overarching company level, enterprise-wide level basis, but on a specific product and service basis. Some products and services are different than others. Not all are subject to the same set of technical requirements that may give rise to a private cause of action in the first place. Some others may. Others may have a whole host of technical requirements that no matter how intricate your computer system is and your compliance management system and people are, the reality is that plaintiffs' lawyers have poked holes in them and made allegations for time immemorial. You want to factor all that in, as well as also realistically, what is the product and service you're offering? What's the consumer risk? And what's the company risk? Now, the impacted parties and business units are likely going to be far broader than you might initially think. It's not just the product and service, but it's also even the consumer support services behind that. Consumers now are going to have perhaps greater incentive to seek out plaintiffs' attorneys. Plaintiffs' attorneys may have greater incentive to seek out consumers. What do you have in place so consumers come to you first? Those are all factors you want to take into account. And then, of course, testing. Now, testing on one hand means, how is your program going to be implemented? So, for instance, if you have to take out arbitration provisions, how are you going to test that? But also consider, too, you may want to start putting arbitration provisions in contracts that are pre-final rule. Those aren't going to be touched by that rule. And perhaps that's where you want to take a more aggressive approach, or perhaps a more efficient approach with respect to consumer disputes than you presently do. A lot of companies have come to us recently and said, should we start changing our contracts now? And I think realistically, before you get to that stage, you have to take a couple steps back and also consider the fact that you could have a bifurcated system. You may have some contracts that have arbitration provisions in them up until the final moment of the final rule. You may have others that you start paring back earlier for whatever reason. You may have some that you've been thinking of implementing new contract provisions where you still do that, but you plan to make changes on the effective date. All sorts of things that you need to take into account. Now, in terms of that implementation, we'll talk about who needs to be involved in that in a moment, but I think it's important to consider also that your policies, your procedures, all your internal controls, they're all likely premised on a foundation of what that existing contract is. So you got to take that into account. And it's really important to communicate internally. So if you're changing your contract, consider all the different folks that need to be alerted to that. You have a normal policy and procedure and a process, a workflow for that. But this is broader than just changing a non-substantive term. This is perhaps changing the entire risk calculus for offering a product and service. So who needs to be involved in the conversation? The Compliance Management Committee certainly does, but perhaps go broader. Certainly every organization has a different culture, a different structure, but I think this is one where clients and companies would be well served by using sort of a broad-based approach to inclusion early on to make sure all the right folks are at the table. Litigation counsel, regulatory counsel, the compliance team, all critical folks, likely already to one extent or another represented on the Compliance Management Committee, but also the business owners for each product and service. Oftentimes, as we all know, there can be sometimes a disconnect between one group's expectations versus another, as well as also what they're planning to do. Customer support, as we mentioned earlier, very important too. The reality is your customer support team, more than ever, if this rule takes effect, is going to be that last line of defense between a consumer perhaps seeking you out for a solution to whatever perceived issue they may have versus the CFPB or a plaintiff's attorney. And there may be others too that are going to be likely candidates to be included. And so what needs to be considered? Of course, the litigation exposure. What's your new last line of defense? How does this impact vendor relationships? How does it impact your contractual vendor relationships with respect to indemnities and reps and warrants? Are you counting on somebody else to have foot the bill for some litigation that you thought there was an arbitration provision for? You want to assess the recourse available to consumers. Not every financial product and service is covered by a statute that has a private right of action. In some cases, there's statutory caps. In some cases, there's statutes of limitations. You got to drill down if you're going to do the cost-benefit analysis in terms of what to do internally on how to do that. And cost-benefit analysis may not be simply, when do we make the change or do we make a change in advance? It may be, do you make a change to your contract terms outside of the arbitration provision? Do you adjust the product and service? And I think, finally, what's really significant too is understand the implementation periods. Not just the ones that are in the proposed rule that we've covered today, not just the tea leaves with respect to possible legal challenges, but your internal implementation periods. We all know many changes cannot happen overnight, and if you're talking about also potential product and service enhancements, adjustments to how different features are presented to consumers, enhanced disclosures, other things to mitigate your litigation exposure, that takes time to consider and it takes time to implement.
Well, thank you, Jonathan. You've spoken a fair amount, and I think it strikes me that it is top of mind for probably everybody on this call. You've spoken a fair amount about assessing risk and assessing litigation exposure and how those considerations inform current and probably forward-looking compliance programs. But I'm wondering, what your thoughts are about, Jonathan, how this would be impacted given there might be some uncertainty around when the rule actually takes effect. And I think one of the issues here is, how preventative do you want to be? How preemptive do you want to be in your compliance rollout? And it strikes me that you probably want to be thinking about this well in advance of the effective date of the rule, and then, of course, counting from there. But
I think that's right. I think you have to work backwards and you have to work forwards. This is a multidimensional issue, and this is one that's really cross-cutting. For some companies, this is, to use the expression, sort of like a Y2K event, but the reality is that there could be an issue down the road. I don't think you can take as a foregone conclusion that this is going to automatically come to a halt because of a legal challenge. On the other hand, certainly we can all consider what those permutations and speculate too. But You got to work backwards, you got to work forwards, you got to take into account each product and service individually and its individual risk exposure. A lending product is very different than a debt relief product, and it's which are also very different than products and services that are really services to financial providers, such as debt collectors. How do they factor in the change in the rules as to how to collect a debt when there's no arbitration provision?
Something else that I'm curious about, Peter, and I'm wondering if you can take us back, the role that the effective date of the rule plays in how companies think about what needs to be within or outside of their current consumer-facing agreements, and the extent to which there could be some potential retroactive effect that this rule potentially could result in, even though there is an effective date in place. And I'm wondering, Peter, what your thoughts are about that, and then, of course, Jonathan, how, again, getting back to this issue of how you put in place adequate controls given some of the uncertainty around this issue.
Well, that's right, Allison. You have a compliance date, and you have language in Dodd-Frank that's being interpreted by the Bureau in terms of when you enter into a pre-dispute arbitration agreement and what that means for your existing contracts. I think in the main, and sort of what we would expect, is that most of your existing contracts entered into before the compliance date really won't be affected by this rule, but they could. So I think it's important to keep an eye on those fringes and see what happens with the comment period, how is this entered into term interpreted and ultimately sort of defined by the Bureau in the rule, and what does that mean for your contracts, but also your practices in updating, renewing, amending your contracts, adding, new services. If you have something new, as Jonathan mentioned earlier, if there's even some concern that you, by adding a new service, could fall within, could bring a whole tranche of your contracts into this rule, which might otherwise not fall within it. Maybe you try to roll that out sooner rather than later to take advantage of the compliance date and getting changes in, so that you have that set of contracts that sort of falls to one side of the rule rather than the other.
Thank you. I want to thank everybody for joining us today. We're about at the end of our hour. And a few things. I want to remind everybody that our slide presentation will be available after this presentation today. You can download it on our website. In addition, if anybody has any questions about anything that they've heard today or anything on our slide deck, feel free to reach out to any of us on this presentation panel. I want to thank all of our panelists today. John Cooney for his understanding and substantial expertise in thinking about how this rule could be challenged in court. Tom Gilbertson for his insights into how this impacts class action litigation and the management of that risk on a going forward basis. Jonathan Pompan for his insight into how companies should be thinking about managing the risk associated with the potential for this arbitration rule and the potential risks associated with increased exposure to class actions and how to think about change management. And Peter Frechette for his excellent explanation and summary about the rule itself and the rulemaking process. Thank you very much for joining us. I'm Allison Baker, and I hope you've enjoyed our discussion as much as I have enjoyed moderating.